Namaste viewers and a very warm welcome to the Indian Lawyer Legal Tips. I am Sushila Varma, advocate and chief consultant with the firm. Today's topic is one which is a burning topic worldwide, that is artificial intelligence. In this episode, we are going to examine whether or not the Indian laws protect artificial intelligence. Before we go any further, first let us try and understand what we mean when we say artificial intelligence. In simple words, I would say it refers to the imitation of human intelligence by machines, enabling machines to think, learn, and make decisions as if they were humans. What AI does is that it increases accuracy while at the same time reducing cost and time factors, which has sadly resulted in a lot of people getting laid off. AI system uses algorithms and data to analyze information, recognize patterns, and perform tasks that were hitherto done by humans and required human intelligence. This process or technology has recently come into the limelight because of the sheer efficiency that it brings with it. Now, before we go any further, let us examine what are the problems that we are looking at when we are talking about AI. The first I would say is that under the Indian laws, and why Indian? Even overseas, you don't really have many laws for specifically dealing with artificial intelligence. Under the Indian laws, the intellectual property laws that recognize the authorship of any creation is generally recognition of creation by a human mind. There is no law which recognizes creations that are created by a machine. Hence, this I would say is the first problem. The second problem that I see with artificial intelligence is that there is no specialized law that pertains only to artificial intelligence, which I just mentioned earlier, is a creation of the machines. So, because there is no specific law, in order to get some protection for artificial intelligence, we have to look at the current existing laws that are there, such as the data protection laws, the information technology laws, and to some extent, the intellectual property laws.
As artificial intelligence does not have any specific law in India, we now have to examine the other laws that are applicable. The first I would say would be the DPDP Act, which is Digital Personal Data Protection Act 2023, which regulates and is applicable to the collection, processing, and storage of personal data. Since AI, as one of its features, collects a lot of data, the persons who are using AI to make any programs must ensure that whatever is applicable under the DPDP Act is followed. Over and above that, the same law makes data fiduciaries, that is, companies that collect or handle personal data, responsible for the data that they are holding. Hence, all AI-based decisions that affect individuals must ensure that explicit consent is given for the usage of such personal data. Data principal rights are also something that has to be examined, such as the right of AI to access, correct, or delete their data. Hence, all in all, the data which is now protected by the DPDP Act is one law that is fully applicable to AIs. Now let us come to the second law, that is the Information Technology Act 2000, which is a law that governs the entire digital world and also governs cybersecurity, online crimes, and electronic transactions. There are two sections, 43A and 72A, that hold organizations accountable for negligent handling of sensitive data. AI-driven crimes such as deepfake frauds, hacking, etc. are also punishable under this law apart from the other criminal laws. AI is now used very frequently by many people for creation of trademarks, designs, logos, etc. Obviously, this would come within the purview of the intellectual property laws such as the trademark law, the copyright law, etc. Now, what generally happens with AI is it does not create a very unique content or a very unique trademark or a design. Invariably, it's a copy from already existing trademarks, logos, designs, etc. Hence, if there is a product or a trademark or a copyright that has been created by artificial intelligence and it violates somebody else's rights, then the intellectual property rights will be applicable, and the person who has used the AI to create such new types of trademarks or designs will be held liable. Now, let us understand one more thing. An AI, even if it creates a unique intellectual intellectual property, such as a unique trademark or a unique design or a unique pattern, it would still not be something that could be recognized under the law, and that particular trademark or design would not get a copyright as it has not been created by a human being. Now, let us examine how AI is covered under the criminal law or how there is civil liability. Earlier, the Indian Penal Code, which is now replaced by the BNS 2023, holds humans responsible for any offences that have a criminal or a criminal liability. As AI lacks a legal entity, the liability will obviously fall on the AI developer. That is, if an AI model is defective and is causing harm, then the person who has got the AI developed would be the person who would be liable. Similarly, if AI makes decisions on the behalf of some business which is using AI and this is causing discrimination or economic loss, again the business that is using it or the legal entity that is using it would become liable, be it criminal or civil, depending on the offense. Also, AI is now being used in sectors like the banking, healthcare, etc. And there are times when there are mistakes or there are violations of the law. In such a case, because these sectors would come under services, the consumer laws would be applicable. Now, a question that may arise in the minds of some of the viewers is, can I get a patent if I have created an AI innovation? The answer would depend on whether or not there is human intervention in the making of that particular invention. If there is human intervention, then yes, the patent law may recognize the invention as being partly made by a human being and thereby grant a patent. But if it is something that is completely done by an AI, it is unlikely that one would get a patent for such a creation. There are certain sections or certain exclusions in the Patents Act which do not allow algorithms or mathematical or business methods or certain computer programs to be recognized as a patent. Much would depend on exactly what is the features that are there in the particular creation. In a recent judgment passed in 2022 by the Delhi High Court, known as Microsoft Technology Licensing LLC versus the Assistant Controller of Patents and Designs, it was laid down that in order for a patent to be granted, the invention must satisfy the patentability requirements, including the requirement for a technical effect or contribution to be eligible for patent protection. In other words, methods, claims in a computer program patents may be patentable only if it involves a technical advancement and provides a technical solution to a technical problem and has an improved technical effect on the underlying software. A little difficult to understand, no doubt, but this is what the law says. Now, probably the most interesting question in this entire episode is, can an AI become an owner, an intellectual property owner of its creation? This, to my mind, is not a very clear yes or no. When an AI program is considered the owner of an intellectual property, there will be challenges as to whether or not such a product that has been created by AI will get the recognition under the intellectual property rights. Some of the significant challenges arise in terms of the infringement, enforcement, and accountability of AI. If somebody was to make a case of an infringement, then can it actually sue an AI? Doubtful. Infringement and enforcement can only be done against an individual or a legal entity, and AI does not enjoy the legal entity status. So, how can one actually go and sue an AI for infringement or for enforcement? Secondly, would an AI be accountable for infringement? Again, the answer would be no, because it does not have a legal personality. Now, what are the steps that can be taken to protect the intellectual property rights? New policies and laws have been implemented, and it is hoped that they will ensure that AI does not create harmful content or take away the rights of human creators. In conclusion, one can say that although AI is a powerful tool for improving efficiency and also reduces costs, it has to be used with restraint and followed in a manner to ensure that there is ethical practices and it does not go against the law. Failure to adhere to the law will obviously make the person using the AI answerable to the law. With this, I would like to end today's episode. Dear viewers, Team The Indian Lawyer is making an effort to try and create legal awareness in as many people as we can reach. I would therefore request you that if you have liked this episode, please like, share, and subscribe to our channel and help us to reach many more people so that our efforts bear some fruit. Thank you for watching this episode. Until we see each other at the next episode, thank you and goodbye.